just the numbers. Yeah, definitely. No, they made it. Well, the House made a decision. Whoever's working on that to examine. It's probably because they don't want to raise electric. They don't want to raise. But I don't know. I am consolidated. Why are you raising mine? I have the shittiest internet. Now you're going to raise my fees. On DSL with consolidated. I'm going to raise my fees. Give me fiber. I'll pay extra. Give me fiber. It was both.
Senate will please come to order. We'll have a moment of silence for our devotional moment of contemplation. Thank you. Are there any announcements? Brief announcement, in case you missed it yesterday, the men's bracket is closed. You still have till tomorrow at noon for the women's bracket for the NCAA tournament. I have one bill for referral under Rule 31 S304, an act relating to Vermont's career and technical education program appearing on the calendar for notice and affecting the expenditures of the state will be added to the pile of bills that the Appropriations Committee is reviewing. I'm sorry, Senator. That brings us to the orders of the day. I want to alert folks that we are not going straight through the orders that are in the calendar because it's unlikely under advice of the pro tem that we will be able to conclude them all by 3 o'clock. And so we are planning to read through the third readings first, and then we will be bouncing around the calendar a bit, and I'll try to keep you informed as we go. Our first order of business is S150. It's an act relating to automobile insurance. Third reading was ordered. Are there any amendments before third reading? Seeing none, please listen to the third reading of the bill.
S150, an act relating to automobile insurance.
Now you've heard the third reading of the bill. And the question is, shall the bill pass? Are you ready for the question? If so, all those in favor, please indicate by saying aye. Aye. Those opposed indicate by saying nay. The ayes have it, and you have passed S150. We now have up for consideration S183, an act relating to planning for the Agency of Healthcare Administration. Third reading was ordered. Are there any amendments before third reading? Seeing none, please listen to the third reading of the bill.
S183, an act relating to planning for the Agency of Healthcare Administration.
Now you've heard the third reading of the bill. The question is, shall the bill pass? Are you ready for the question? If so, all those in favor, please indicate by saying aye. Aye. Those opposed indicate by saying nay. The ayes have it, and you have passed S183. We now have up for consideration S213. S213 is an act relating to regulation of wetlands, river corridor development, and dam safety. Are there any amendments before third reading? Seeing none, please listen to the third reading of the bill.
S213, an act relating to the regulation of wetlands, river corridor development, and dam safety.
Now you've heard the third reading of the bill. The question is, shall the bill pass? Senator from Rutland.
Thank you, Mr. President. If I may interrogate the reporter of the bill on the section for wetlands.
Can I get a signal? Senator from Windsor is interrogated as the reporter of the section on wetlands.
Thank you, Mr. President. Just had a question on the section of wetlands. And I'm going to reference yesterday's copy of the Senate calendar. Page 1099, section B, there's a sentence there that the secretary shall mandate that the permit application restore, enhance, or create wetlands or buffers to compensate for the adverse effects on the wetland. And I'll pause if the reporter needs to catch up.
Yeah,
Okay, so that's
could you repeat the page number?
Sure. So this is yesterday's Senate calendar. 1099 is the page. The paragraph is B towards the top of the page. And I'll repeat the sentence if necessary. Okay, so this, you want me to repeat the?
Yeah, yeah, go.
Okay, so in paragraph B, about 4 lines in, the secretary shall mandate that the permit applicant restore, enhance, or create wetlands or buffers to compensate for the adverse effects on the wetlands. And then further down the same page in paragraph C3, there is a sentence about the minimum 2-to-1 ratio of restoration to loss to compensate for permanently filled or drained wetlands would be the desired effect. The question that I have for the reporter, this came from a constituent, was that the comment that the reporter made about mitigating damages done back to the colonial days was a bit unsettling. And if there could get some clarification to what the current landowner's responsibility is for mitigation of previously adverse effects. How far back does that responsibility go?
Mr. President, I think you're combining a few different points, and the question does not necessarily reflect the statute that we're talking about, but I want to try to address your question to what I believe you are trying to get at. So what you're referring to, I believe, is present wetland rules, and you're asking me what are the wetland rules now for a person who has property that has a reduction or is filled wetlands, and your question is if they have to go back to the standard of pre-colonial times. Is that your question?
Well, Mr. President, the statute, the legislation that's in our journal is clearly highlights what's new text and what's old original text. This is all new text, and the 2-to-1 compensation ratio for the current landowner. How much responsibility do they have given the time that the wetland was adversely affected? Does it go back to the point where they bought the property and they are responsible for that adverse effect, or back, as it was alluded to in the testimony yesterday, that it goes back to the colonial days, which was a little alarming for my constituent?
Oh, I think I might understand where your constituent is being confused. The terms I used in my floor report yesterday was referring to that we have seen 35% of our wetlands, 35% have been reduced since pre-colonial times. Obviously, if you're a property owner, what we're talking about is any changes you're making to a wetland currently. So this is looking at new permits, not retroactive.
Okay, thank you, Mr. President. Thank you.
Question for the Senate is, shall the bill pass? Are you ready for the question? If so, all those in favor, please indicate by saying aye.
Aye.
Those opposed indicate by saying nay.
No.
The ayes appear to have it. The ayes do have it, and you have passed S-213. We now have up for consideration S-246. S-246 is an act relating to amending the Vermont Basic Needs Budget and Livable Wage. Third reading was ordered. Are there any amendments before third reading? Seeing none, please listen to the third reading of the bill.
S-246, an act relating to amending the Vermont Basic Needs Budget and Livable Wage.
Now you've heard the third reading of the bill. The question is, shall the bill pass? Are you ready for the question? If so, all those in favor, please indicate by saying aye.
Aye.
All those opposed indicate by saying nay. The ayes have it, and you have passed S-246. I'd like to momentarily request the senator from Franklin to not use an electronic device while on the Senate floor. But I am glad to see you, I might add as well. It's good to have you back. We now have up for consideration S-305. S-305 is an act relating to miscellaneous changes related to the Public Utility Commission. Third reading was ordered. Are there any amendments before third reading? Seeing none, please listen to the third reading of the bill.
S-305, an act relating to miscellaneous changes related to the Public Utility Commission.
Now you've heard the third reading of the bill. The question is, shall the bill pass? Are you ready for the question? If so, all those in favor, please indicate by saying aye.
Aye.
Those opposed indicate by saying nay.
No. No.
The ayes appear to have it. The ayes do have it, and you have passed S305. We now have up for consideration H801, an act relating to approval of the adoption of the charter of the town of Waterbury. Are there any amendments before third reading? Seeing none, please listen to the third reading of the bill.
H801, an act relating to approval of the adoption of the charter of the town of Waterbury.
Now you've heard the third reading of the bill, and the question is, shall the bill pass? Are you ready for that question? If so, all those in favor, please indicate by saying aye.
Aye.
Those opposed indicate by saying nay. The ayes have it, and you have passed H801. We are now going to continue to the third page of your calendar list and take up S18. S18 is an act related to banning flavored tobacco products and e-liquids. The Senate passed the bill and referred the bill to the House. The House has considered the same and recommends that the bill was amended and has returned the bill to the Senate. The question now is, shall the Senate accept the amendment or concur with the House on S18? Are you ready for the question? Senator from Chittenden Southeast.
Thank you, Mr. President. Senate Health and Welfare has reviewed the bill as it returned to us from the House, and we ask for a concurrence with the House proposal of amendment. Very briefly, I will go through what has come back to us. As you recall, this bill is with regard to e-cigarettes, addictive nicotine products, as well as menthol tobacco products. So it would end the sale of flavored e-cigarettes and nicotine products, as well as menthol tobacco products, with an effective date of January 2026. What is not included in this are cigarillos, cigars, shisha, dip, chew, and similar, some similar products. Roll your own snuff, cigarettes, smokeless tobacco, and other similar products. That also would be effective in 2026. Also included in the bill are studies to address equity issues related to consumption of these products, a directive to the Vermont Department of Health to develop a cessation alternative to youth penalties, elimination of tobacco coupons and funding to enforce online sales. Tobacco flavored cigarettes and e-cigarettes would still be available without flavors. And those things would go into effect in 2026. There is as I said, the ban that would be in effect in 2026. That would allow for an opportunity for the Vermont Health Equity Committee to review the effect of menthol, removal of a menthol on some of our populations that have been targeted by the tobacco industry with strong marketing. This strengthens the cessation options. It allows for cessation treatment through the Department of Health. It will, in place of fines, allow kids to go through those cessation programs. And it also will allow for the liquor and lottery folks to evaluate online sales of and purchases of these products and to limit those. The other, I think that's kind of the general part of the bill. I will go through it a little bit more, but I think that those are the basic components of the bill. I can go through section by section, Mr. President, very briefly. One of the things that the other body did was to coordinate definitions into one section of statute and to allow for some improvements to statutory language, so it's easier to read and to understand all of the statutes related to e-cigarettes containing nicotine and tobacco products containing menthol. So there are some definitions, some broadening of definitions. In the first section is about tobacco use and findings. The second section is with regard to organizing the definitions, updates terminology for e-liquid use. It adds a prohibition on knowingly enabling the use of tobacco products and tobacco substitutes or flavored e-liquids and e-liquids by a person under the age of 21. So that's part of our existing prohibition on sales to folks under 21. That section also has some updates on the fining and the penalties for the sale of BDs, which are a form of delivery for nicotine. Adds e-liquids throughout the sections of the bill related to that. Deletes the penalty for sale to a minor because that was moved to another section. So there's some coordination and some improvements to the structure of the bill. The section 1070 SA 1009 is contraband and seizures, the same as we passed from the Senate. It adds e-liquids to the section on internet sales, which then would include e-liquids, tobacco paraphernalia, and other products that were in originally in another section, but puts those all together. It revises the language for consistency with updated terminology in the bill. So that is similar to what we did, but adds some updated information. It prohibits the sale of flavored tobacco substitutes, flavored e-liquids, and menthol flavored tobacco products effective January 1st, 2026. Violation of the ban on flavored items is subject to civil penalty up to $200 for the first offense and up to $500 for those sales for a subsequent offense. That goes into effect in January 2026. Prohibits the selling or offering of tobacco products or tobacco substitutes, e-liquids, or tobacco paraphernalia at a lower price. This was a provision that the Department of Health asked for. It relates to coupons that manufacturers give to retailers so that they can sell, or wholesaler level, so they can sell the tobacco products at a lower level. The bill also prohibits, that's the coupon section. And then it talks about structures the Judicial Bureau collection of data of fines. Section 4 is the same as what we had passed on e-liquids. Section 5 adds e-liquids to the existing ban on using tobacco products and tobacco substitutes on public school grounds. So it's an update to prior language. It updates headings and clarifies references. It deletes permissive language regarding public school board adoption of policies. So school boards don't need permission. They already adopt policies. This all goes into effect in January 2026. And then it updates the ability of for healthcare professionals to treat for treatment on nicotine as they can already for other substance use disorders. There's some good, section 7 and section 8 are the same as in the Senate passed bill, but are become effective in January 2026. It updates, amends the Department of Health Prevention and Treatment section to specify that minors' use of a quit line can be based on the minor's use of tobacco substitutes or e-liquids. So now it expands the use of that quit line. Section 10 updates reference to our definition of statutes dealing with a master settlement agreement for tobacco manufacturers and related issues. It required section 11 requires the Health Equity Advisory Commission to include in its annual report due in January 2025, a recommendation on whether the sale of menthol tobacco products, including menthol cigarettes, should be banned in Vermont. So the report would come in January 2025. The effective date for any ban on any flavors or menthol goes into effect on 2026. Section 12, we have similar language from it relates to the Office of Attorney General delivering a report on how and if and to what extent the state might regulate advertising and labeling for tobacco substitutes and oral nicotine products and e-liquids in Vermont. Section 13 is the same as our section 9 in our bill. And section 14 allows for the Department of Health in consultation with the Division of Liquor Control and Court Diversion Programs to develop options for diversion to a tobacco cessation program for persons under 21 as an alternative to civil penalties and fines. And that report is due on January 15th, 2026. Creates a new investigator position in the Department of Liquor and Lottery from the Tobacco Litigation Settlement Fund, which allows for those investigators to look at sales, internet sales of these of products, and then to bring a report back on March 15th, 2025, and continue with annual reporting until and unless we have no further internet sales of these products, illegal sales. So most of the provisions that are in the bill, what goes into effect on passage would be the request of the Health Equity Commission to investigate whether or not and how or whether the state of Vermont should regulate menthol tobacco products. And then most of the effective date for the ban of any flavors is for e-liquids is in 2020, January 2026. So, Mr. President, that's a report from the committee. Obviously, it's a critically important bill for prevention. It's a critically important bill to reduce addiction, nicotine addiction in our state. People don't have a choice about being addicted. We've said that in our committee many times. And kids especially don't have a choice when they confront the abusive effects of nicotine. So, Mr. President, your Committee on Health and Welfare did vote 3-2 to advance this bill forward and to pass it. And we asked the committee to please concur, the Senate. We're not a committee, we're a committee of the whole. But I do ask sincerely, this is important for our state and for our kids. Other states have already done it. They're seeing the benefit of having done this in many ways. I know there will be questions, fiscal questions, that's perfectly legitimate. However, I will say, and my committee members, I hope, will also contribute to this, the millions of dollars that we save in healthcare costs are worth the few millions, very few millions comparatively, that we lose in revenue. So, Mr. President, I ask the committee's, the Senate's concurrence with our proposal. Thank you, Mr. President.
Senator from Bennington.
Thank you, Mr. President. May I inquire of the presenter?
Senator from Chittenden Southeast is interrogated as a presenter of the bill.
Thank you, Mr. President. The one question that I continue to get from constituents has to do with pipe tobacco, and I'm just wondering if you could please clarify the pipe tobacco piece, flavored pipe tobacco, where everyone has landed on that issue.
So all I can say at this point, yes, that is any other tobacco products that are not not flavored, because federal government is dealing with flavors at tobacco side, but they're not covered in this bill.
Okay, thank you, Mr. President.
Senator from Rutland,
Thank you, Mr. President. May I inquire the report of the
Senator from Chittenden Southeast is interrogated as a reporter of the bill.
The reporter did bring up the financial impact, and I'd just like to pursue that for a second. While I sincerely do realize the negative health impacts of the products that we're talking about, I do want to at least question whether the committee heard any testimony or got any information about the potential economic impact of the state in terms of foregone revenue.
Thank you, Mr. President. In terms of revenue, we did have a fiscal note. It was slightly different from the fiscal note we received last year on the bill that we passed, but consistent. Our joint fiscal office did a deep dive and did a comparative analysis of what's happening in California, New York, and Massachusetts. The state in early years it's difficult to say how many people will switch from flavored products to unflavored products. And so there were a lot of caveats that were given to us in the estimate, but the loss of revenue in 2026, which is a half a year, would be approximately 3.0 to 5.4 million dollars in revenue. In 2027, the prediction is a loss of revenue of 7.1 to 14.2 million dollars. Joint fiscal does not compensate for healthcare savings. So they, while they are understanding that there will be savings, they didn't include that information in the report. And the amount of savings, and I might at some point allow for my other committee members to weigh in on this, but they're in the hundreds of millions of dollars in healthcare savings, not just in the long term, but shorter term. So that's it.
I thank the senator. Thank you, Mr. President.
Question is, shall the Senate concur with the Senator from Essex?
Thank you, Mr. President. Can I require a report of the bill?
The reporter is interrogated.
Mr. President, when we're looking at all the addictiveness of the flavors that we're trying to ban here, did the committee take up any of the flavors of marijuana? Because I was in the marijuana store just to prepare for this, and there's no regular flavors of marijuana. It's all flavored marijuana. So did the committee take up any of that?
No, Mr. President, it wasn't in our bill.
Okay. Did the committee take any testimony on about the harmful effects of flavored alcohol?
No, Mr. President, it wasn't in our bill.
Did the committee talk to any of the store owners along any of the rivers going into New Hampshire about what type of impact that they thought that might bring to those small communities up and down the Vermont, New Hampshire River?
So I'm trying to recall who all we had in last year, because that was when we took testimony on all of this. And we did hear from folks, and we did hear, and we've also heard from Massachusetts that there's initially a loss of sales, that the sales will migrate to the other state. And then after a year, that changed. And that we also heard from Massachusetts that our small businesses their small businesses were not affected. In fact, they were prospering very well. So it's, of course, that's always a concern that people have. If you live over on the west side of the state, New York has already banned this, Massachusetts has done this, and so there are a few places in New Hampshire, I guess. But no, we did not hear that there was going to be death of the small retailers.
I think the reporter, Mr. President, I have spent some time on the New Hampshire River. It's where my district is. And I have a friend of mine that has two stores. He lives in Vermont, but has two stores on the New Hampshire side. used to have a store on the Vermont side, but because of laws like this and other high costs of doing business, he's moved across the river. He's actually clearing out in both his stores non-performing stock for the onslaught of sales that he understands is going to come. And he doesn't come by it lightly. He's actually talked to people on the borders of Massachusetts and to people on the borders of New York that have seen just an incredible influx of business. My friend is thinks that a third of his non-performing inventory is going to be cleaned out, and he's going to make room for that. And on one of the stores, he actually thinks he's going to have to put an addition on. As far as on this store. So, you know, we can talk about the negative impacts of only 14.9 million. We've heard as high as $20 million. But it's not just that. It's the fact that these people are going to the stores to pick up their tobacco products, and it's what else that they buy. These stores, and they don't make, these mini marts do not make their monies just on one product. It's got to be a combination of products, from gas to chips to soda to beer to tobacco to what might have you. And so you can't just say, well, it's only going to be like $14.9 million. It's probably, I don't know, I wouldn't even want to even say the amount. I know that one store owner in Bloomfield is very concerned about it. Already, as I've mentioned, the stores on New Hampshire have such a business advantage over doing business in the state of New Hampshire versus the state of Vermont. We've had this little DeVanville store right in Bloomfield, and it's struggled. We have a new owner in there, and this is just a tipping point enough to cause him a lot of concern whether he's going to be able to compete moving forward. And I would dare say that probably he's not. In Essex County, there is a high amount of tobacco use. You know, it's just what it is. And the river's right there, the store's right there. In fact, you can see the one store from the other if you stand just correctly. And so the impact isn't going to be 14.9 million. It's going to be millions and millions and millions of dollars, lost revenue, lost business. And it's not going to stop people from doing with what they do. And the fact that we're targeting just one business, and we have this marijuana industry, which is all about flavors. It's all about it is. It's gummies. It's everything you could possibly do. And as I said, you can't even walk into a marijuana store and see anything that's not flavored with something. And then, of course, the alcohol is, we tried prohibition once with alcohol. It failed miserably. It caused a lot of damage in this country. But just very bothered that we would go and just pick out one industry and create impact where Vermont's struggling as it is right now. And the thought that we're going to come up with these millions of dollars of extra monies that's going to take away from the state of Vermont and tax revenues and these business owners is just something that I just can't support. Thank you, Mr. President.
Senator from Washington.
Thank you, Mr. President. Just a point of clarity. The question before us is whether or not to accept the amendments made by the House. The Senate has already passed this bill, and this, I believe they're extending the dates. And that's what we're not voting on the bill as a whole, it's just on the amendments.
That is correct. The vote is to concur or not concur with the House proposal of amendment. Senator from Chittenden Southeast.
Thank you, Mr. President. I wanted to clarify and follow up with the data that our Department of Health has provided, because a question was raised regarding convenience stores. Department of Health in Massachusetts has indicated that convenience stores in Massachusetts have increased their revenue. After the first year where revenue drifted over to New Hampshire, then other products were compensated for those losses, and those smaller businesses and smaller stores survived. So it's actually a 6-month period of the downturn, and then it came back. And I know we've already passed this bill, and the issues around marijuana or cannabis and alcohol have been debated. And so I won't add to that conversation. Thank you.
Senator from Chittenden Central.
If I could just expound a little bit on what my chair is saying, I did want to add that I know a lot of folks are worried about the health of our small convenience stores, but the data just does not underscore what we've heard. In Massachusetts, the data coming out of Massachusetts in February of 2020, there were 3,767 convenience stores, and in April of 2022, 3,994. So they've actually grown in number. I just wanted to share that with folks. A couple of other quick bits of data around the financial costs. I think it's important to underline that smoking directly causes $404 million of annual healthcare costs in Vermont, with 94 million costs to Medicaid. The 2022 tobacco tax revenue was less than the cost of just Medicaid smoking related expenditures at 76 million. So, you know, what we're going to save in Medicaid is far, you know, outshadows the money that we make in tax. 576.2 million in smoking caused productivity losses is what we see in Vermont, in the Vermont workforce, not including secondhand smoke, smoking related fires, and other tobacco use. So I wanted to highlight that. Thank you.
Thank you, Mr. President. If I may I read a small section from a letter from a constituent regarding this bill?
Without objection, you may.
Thank you. I wanted to share with you a little bit from a letter that was printed in local media from Kelly McGovern Landwehr, who is the school nurse at the Middlebury Union High School, where my kids go and have gone, and she's the president of the Vermont Nurses Association and the mom of a teenager who has had struggles with a vaping addiction. Nurse Landwehr says that nicotine, tobacco, and e-liquids are unequivocally harmful to the brain and the lungs of children. Teens and young adults are developmentally far more susceptible and vulnerable to becoming addicted to nicotine. To prevent the harms of these products, we must eliminate what is drawing kids to them in droves, and that is flavors. As a school nurse, this is what I observe on a regular basis. Addiction to nicotine products becomes the priority. Student education is interrupted as kids skip class to feed their nicotine addiction. Students reach out to the school nurse and to the substance use prevention specialist, scared and wanting help. Parents of children addicted to nicotine reach out, desperate to help their children. Students are alarmed to feel their hearts racing and feel very anxious, restless, and frightened. Students use social media to arrange meetups within the school to vape together. Students who have started vaping seek help for a chronic cough or shortness of breath. Students use nicotine products socially and quickly, becoming addicted when they never intended to. They didn't realize that vapes, cigarettes, and flavored cigars were harmful or addicting. Students say appealing flavors draw them to vaping. And athletes have new health effects that interfere with playing the sports they love. Students have been diagnosed with serious and sometimes irreversible lung conditions due to vaping. 2 days ago, this body voted unanimously to approve a bill that would prevent social media products from damaging our children. Unanimously. And then unanimously to support a bill that would create a policy to apparently protect kids from cell phone use in school. Unanimously, we voted to help our kids, prevent them from being damaged by dangerous products in school. That is exactly what this bill is doing. It is trying to prevent kids from being harmed from dangerous products that they are using in school and out of school, that is preventing them from getting the education they need and causing serious long-term and short-term health effects for students. I know that this bill has revenue impact, but as Nurse Landwehr says, our children are worth more than the revenues of these products. I urge all of you to do what we did as a body 2 days ago and to support a bill that is meant to protect our kids from harmful products. Thank you, Mr. President.
Excuse me, the question is, Senator from Rutland.
May I ask for a brief recess, Mr. President?
We'll declare a brief recess till follow the gavel.
Yeah, no, that's different.
Senate will please come to order. Excuse me, the Senate is in order. Question is, shall the Senate concur with the House proposal of amendment? Are you ready for that question?
Roll call.
Roll call has been requested, I believe, by the Senator from Essex. Senator from Franklin.
Mr. President, but perhaps I've forgotten. I thought we already banned the use of tobacco for children. I wonder if the reporter of the bill could tell me if I'm right.
Would the Senator from Franklin care to interrogate the Senator from Chittenden Southeast?
Thank you, Mr. President. It is against the law currently for anyone under the age of 21 to be sold tobacco products. What what the bill is doing is, has evaluated the very attractive flavors that are drawing kids into e-liquids and menthol that's drawing various populations into nicotine addiction.
I thank the reporter. I think what the reporter essentially has told us is that the ban didn't work. Making it illegal for a particular group didn't work. Just like banning alcohol in the 1920s didn't work. And just like many people in this chamber got up and told us that we needed to legalize the smoking of cannabis because the ban on cannabis didn't work. And maybe that's a message. Bans don't work when they affect something that people want. I can't tell you how many letters I've received from constituents since this bill has been around saying, I'm an adult, I make my own decisions, and it's none of the business of government to tell me that I can't make that decision. Now, I've looked at some of the same statistics that have been reported here. And one of the things about statistics is they can sometimes be misleading. There's a book, in fact, called How to Lie with Statistics. It was very popular in the late 1970s. And the statistics regarding convenience stores elsewhere tell a story, but it may tell a different story than it would appear on the surface. Because what happens so often is that people decide to change products. If you like to smoke, you know, it's easy to quit smoking. I used to smoke. I quit smoking. Of course, I quit for a different reason. I was in the Army at the time, and the price of cigarettes went up from $1.90 to $2 a carton. That was my motivator. But otherwise, people who didn't buy flavored tobacco in Massachusetts when the ban came may have stopped using flavored tobacco because what we saw was a concomitant increase in the amount of tobacco sales and tobacco tax revenue immediately following that, to which New Hampshire benefited. And that was very, very obvious. The statistics were overwhelming. But one of the questions to really ask yourself is, did people stop smoking? And there's not any real evidence to support that. Because in particular, what happened very possibly is that people changed what they smoked and stopped smoking flavored tobacco that wasn't available and started using either menthol tobacco or other unflavored tobacco. The jury's still out on whether or not that evidence supports that. But the issue overall, to the people who constantly contacted me on this subject, is I'm an adult. Juveniles can't buy this product. It's not available to them legally to sell. The Department of Liquor and Lottery tells me that their program is working as far as stores in Vermont are concerned, and stores are not selling illegal substances to minors. They're getting it someplace else. They're getting it over the internet. This bill doesn't do anything to solve that problem. It's getting it from adjacent states. Nothing in this bill solves that problem. But what it does do is it affects adults who've made a decision. We may not agree with that decision. We may think it's an unwise decision, but it's their decision to make. And we know from time and time and time and time again, prohibitions don't work. That's why this bill should be defeated. Thank you, Mr. President.
Senator from Windsor.
Thank you, Mr. President. I felt passionately about this bill when we voted as a chamber before. I feel even stronger in my support and voting yes to concur with the House. Earlier this week, with the help of a nurse, after more than a week at Dartmouth Hospital and Medical Center, I took my mother in a wheelchair with a tank of oxygen out of the hospital. The reason my mother was in the hospital for so long, and this is not her first time, was because she has a condition called COPD emphysema. She started smoking cigarettes when she was 12 years old. It was not a decision for her to smoke or not to smoke. It was not a decision for her to become addicted to a corporate-backed product. A corporate-backed product that profits off the fact that people are dependent on a substance because at a young age, a vulnerable age, whether that be 12, whether that be 21, whether that be 25, you become addicted to that substance and you are unable to quit. The concept that it is easy to quit smoking, I can tell you firsthand, it is not easy to quit smoking. In fact, it's so difficult to quit smoking that the only time most people end up quitting smoking is when their health or the health of those around them is in such jeopardy that they don't have a decision, that they don't have a choice anymore. I'm disturbed by the rhetoric that this is a decision and a choice. I'm disturbed that we have not discussed the tax revenue as it relates to the suffering and the cost to individuals and to families. I will be voting yes for this bill, and I will be voting yes for this bill because I had to sit there while my mother felt like she was drowning because her lungs were unable to process oxygen because of an addiction she had to a product that a corporation tactfully, strategically, maliciously targeted her demographic of people to smoke. Thank you.
Mr. President, could you state the motion that we're voting on? Because I think a lot of the discussion has been on the bill as it was voted out of here a year ago.
So as the bill goes through the various processes, there are different stages. At this moment, the question is, shall the Senate concur with the House proposal amendment? The House amended the Senate bill with the language that's before you. It has been asked of me during the break that we took a little bit about the process. A yes vote is a concurrence, means the Senate approves the same language as the House. And at that point, the bill goes through the procedural processes to go to the governor. A no vote means the bill remains in the Senate in perpetuity, essentially, until, or if not taken, further action could be taken. Senator from Chittenden Southeast.
Thank you, Mr. President. To that point, I do want to highlight a change that the House made that we would be taking a vote on now that I think specifically helps our small businesses and levels the playing field for them in the context of this ban. If people would want to turn to page 1296 of today's calendar, highlighted is a new position that was created and has an attached appropriation for an investigator in the Department of Liquor and Lottery, specifically for online sales. Your Committee on Economic Development, Housing and General Affairs began to take testimony specifically this week on all of our various vices and substances that we consider illicit or have brought into the regulated market and where we are with enforcement. And whether it's alcohol or vaping products, you name it, the internet is a big place and you can purchase a lot of things. And that, from what we heard from businesses, that specifically creates an uneven playing field for our bricks and mortar stores. For many of them, the idea that they would have to participate in this ban, but it was so easy to buy these products online, was one of the biggest insults of this type of ban. And I think the House did us, the other body did us a great service by creating an investigator position that I hope people will support and vote yes to support our bricks and mortar businesses, because we need this on a number of fronts. And this is an important additional position for the Department of Liquor and Lottery. I do want to remind the body as well that in addition to your Health and Welfare Committee, your Senate Finance Committee took a lot of testimony on this bill when it originally passed our chamber. I specifically remember our unanimous 7-0 vote because it felt pretty monumental after everything that we heard. We not only heard from businesses who talked about the effects to their economic well-being and the effects to the revenue of the state. But we heard from kids. We heard from kids directly who said, my friend OD'd in the bathroom because they had an e-cigarette laced with fentanyl. We heard from school administrators who said, we don't have enough money to deal with the problems in our schools around enforcing the use of tobacco and the use of illicit products. We heard about a lot of costs that just can't be accounted for in this bill. And we heard specifically and directly from young people. So, raising the age didn't necessarily work. And when something doesn't work, we don't just undo the laws that we have on the books automatically. The Economic Development Committee has looked at things that we have brought into the regulated market instead of keeping them in the illicit market. But we did not make a decision to affirmatively do that in this context because tobacco is extremely harmful and addictive. And I think many folks have heard the news that the tobacco industry has seen the writing on the wall and they're looking at other products that mimic menthol to add to their repertoire of addiction. So I wanted to say that before people take this specific vote, as was pointed out by the senator from Washington, you would be saying no to a position that helps us level the playing fields for our in-state businesses.
Question is, shall the Senate concur with the House proposal of amendment on S18? Are you ready for the question? If so, the secretary shall commence to call the roll.
Senator Baru,
Yes.
Senator Bray,
Yes.
Senator Brock,
No.
Senator Campion,
Yes.
Senator Chittenden,
Yes.
Senator Clarkson,
Yes.
Senator Collmore,
No.
Senator Cummings,
Yes.
Senator Bewley,
Yes.
Senator Hardy,
Yes.
Senator Harrison,
Yes.
Senator Hashim,
Yes.
Senator Ingalls,
No.
Senator Kitchell,
No.
Senator Lyons,
Yes.
Senator McDonald,
Yes.
Senator Mazza, Senator McCormack,
Yes.
Senator Norris,
No.
Senator Perschlick,
Yes.
Senator Ron Hinsdale,
Yes.
Senator Sears,
No.
Senator Starr,
No.
Senator Pihovsky,
No.
Senator Watson,
Yes.
Senator Weeks,
Nope.
Senator Westman,
No.
Senator White,
Yes.
Senator Williams,
No.
Senator Renner,
Yes.
Senator Mazza,
Please listen to the results of your vote. Those voting yea, 18, those voting nay, 11, and you have concurred with the House proposal of amendment on S18. We now, I believe, are moving to S58, an act relating to increasing the penalties for subsequent offenses. Excuse me, Senator from Chittenden
If I
Central.
might, the intention was to move to the top of the calendar, to take up H 554, then S 58.
Okay.
Apparently.
I don't think
I'm
that's what I,
Seeing,
I'm going to ask for a brief recess.
But that's okay. I mean,
Yeah,
I didn't.
Senator, please come to order. Turns out we are going to continue with S58. S58 was read for the first time, referred to the Committee on Judiciary, which considered the same and recommends that when the bill is amended, the bill ought to pass. Please listen to the second reading of the bill.
S 58, an act relating to increasing the penalties for subsequent offenses for trafficking and dispensing or sale of a regulated drug with death resulting.
Now you've heard the second reading of the bill. For the report of the Committee on Judiciary, the Senator from Bennington.
Thank you, Mr. President. Change subjects a little bit from the prior discussion and talk about violent crime. S58 is part of two bills that we will see this year that deal with violent crime in Vermont. The bill dealing with conditions of release, S195, will be up shortly in a few days. But I thought I would start out by talking a little bit about violent crime in Vermont. As everybody here knows, we're a small state. So crime rates are based on 100,000 people. We only got 700,000 of them at best, maybe a few less. So whenever something happens, the rates can skyrocket or really low. And so, you know, we have to take that with a grain of salt. The governor has mentioned several times that Vermont violent crime rate increased by 56% from 2012 to 2022. That is correct. And I'm not here to say that violent crime is not a problem, that violent crime is not happening in our communities, and that we shouldn't deal with it. I'm here to say we have to deal with it. So let's put a realistic face on that. It's actually, in Vermont, violent crime is down 2% less than on national average. So per 100,000 people, our violent crime rate is lower. If we look at some other, this is all from the Justice Center, which is where the governor got his figures. In Vermont, aggravated assault rates have increased 65% between 2012 and 2022. Robbery is actually down by 27%, 2012 to 2022. That's an interesting fact because we hear so much about robbery, retail theft, etc., but it's actually down. Rape incidents are up by 76% between 2012 and 2022. I suspect some of that is due to changes that we've made in the legislative process to make sure that it's easier for people to report crimes, easier to deal, not that it's easier to deal with crimes, but certainly easier to report. We've paid more attention to it. We've developed special investigative units around the state. We've done an awful lot, and so you would expect to see that. What is really disturbing to me is that between 2012 and 2022, we've seen an 18% increase in unsolved violent crimes. Why is that important? Well, it's important because if the crime's not solved, you haven't caught the perpetrator, you haven't done anything with whoever did it, and the victim is harmed, and nobody's held accountable. One of the things the Justice Center recommends is that solving more violent crime will deter future violence. Research is clear that the certainty of getting caught and not the severity of the punishment is what deters crime. So as we talk about various violent acts and so forth, please keep that in mind. S58 is going to have things that many of you don't like, things that many of you like. It's built on compromise within your Senate Judiciary Committee. And I will say from the beginning, the vote was 4-1 in favor of the bill, 1 against. It deals with 5 particular areas. One is additions to the Big 12, which are the most serious crimes where a juvenile can be treated as an adult. And actually, we add 3 and subtract 1, to make it 14, by the way. Secondly, it deals with raise the age, which was the effort to raise the age in 2020 of persons who did not commit one of the big 14, big 12, currently, to juvenile court if they were 18. This bill will add to the 19-year-olds that have been delayed 3 straight sessions. It also deals with drug crimes and drug overdoses and the penalties for death resulting from drug overdoses. It also deals with so-called trap houses. And I will try to go through the bill as best I can, starting with the beginning on page 1186. And I did like, by the way, as I was quoting statistics, I wanted to mention that I was interested in the Senator from Franklin's comments about statistics. For a long time. Anyway, the big 12 offenses, those of you who are familiar with them, they include everything from murder to sexual assault to aggravated sexual assault and so forth. One of them that we have struggled with for years in judiciary is burglary into an occupied dwelling. And what we found through statistics was that it's very rarely used. And in the cases, there was a lot of concern that an occupied dwelling is really not occupied. This taking number 12, burglary in an occupied dwelling, does not make it legal, does not make it all right for a 16-year-old to break into your house. They can still be taken up to adult court if the prosecutor wants, through processes that are available today for any crime, any felony crime. So I want to make that clear. What we do add to the Big 12 is the crimes is 3 crimes. One is use of a firearm while committing a felony. Second is drug trafficking, and the third is aggravated stalking. And those 3 crimes would be only affected for 16-year-olds and over, 16 to 19, should the new law regarding raise the age pass. So those are the 3 new ones for a total of 14. And that was a decision of the Judiciary Committee, a lot of discussion, a lot of compromise. It is similar to what was passed by the Senate last year in S4. You remember that bill. Next section, and I will go through a little more detail on some of the sections, is raise the age. And I wanted to, during the process of dealing with this bill, we were asked by the administration to delay raise the age again to the 19-year-old. And at the same time, interestingly, a report came out from Columbia University's Justice Lab, the emerging adult process, on the success of our raise the age to 18. I may read from that article or that report, Mr. President.
Without objection, you may.
Vermont has, however, reported on the number of delinquency cases filed each year for all youth, which starting on July 1, 2020, included youth who allegedly committed an offense before the 19th birthday, and the results are encouraging. Despite incorporating the cases of most 18-year-olds into the juvenile justice system in fiscal year 20, the chart below shows the delinquency case filings have remained fairly stable. And the most recent data for fiscal year 23 shows that there were less filings than before the pandemic began, and also before the 18-year-olds were added to the juvenile delinquency system. It would be reasonable to assume that there will be an increase in the number of delinquency cases filed when Vermont implements phase 2 of raise the age and incorporates 19-year-olds in the system. But as with the recent example of the implementation of phase 1, Any increase is likely to be minor and temporary, if there's an increase at all. And the purpose of the legislation, I may remind you, was that providing more effective, developmentally appropriate responses to system-involved youth, Vermont sought to support youth in preventing crime and successfully transforming into healthy adulthood. So quite the opposite from what one might expect. So actually, we're safer due to raise the age than we were before, according to the project. Next subject. I'm going to go to the president. I think I'll go to the section by section outline here. And we already discussed the Big 12 and the raise the age. And then the more difficult one is the drug crimes. And I want to start with fentanyl. Our testimony in committee indicated that 100% of the glassine bags that your Department of Public Safety lab examines contain fentanyl. 100%. Not 90, not 80, 100%. And that gets us to the term knowingly. So current Vermont law, oh, by the way, fentanyl is 50% stronger and often cheaper than heroin. It's highly potent, it's inexpensive, and demand is high and driving the supply. This is from the Department of Public Safety. Current Vermont law and case law knowingly means actual knowledge that one or more preparations, compounds, mixtures, or substances contain the regulated drug identified in the applicable section of this chapter. So you have to know that the fentanyl was in it. And the prosecutor has to prove it. Despite the fact that we know 100% is in there, 100% of the heroin sold as fentanyl, 100. Knowing for drug crimes, it means actual knowledge that one or more preparations, compounds, mixtures, or substances contain the regulated drug identified in the applicable section of this chapter, or conspicuously, consciously ignoring a substantial risk that one or more preparations, compounds, mixtures, or substances contain the regulated drug identified in the applicable section. So what we're doing here is changing the knowingly standard. No question about that, Mr. President. But where did we come up with this crazy idea? Well, it's rooted in federal law, actually, Mr. President. And a jury charge at the federal level, when charging unconscious avoidance, jury must be told that the knowledge of existence of a particular fact may be inferred if the person is aware of a high probability of its existence unless he actually believes that it does not exist. Juries are also normally to be told that showing of negligence, mistake, or even foolishness is not enough to support the inference of knowledge. That's why I know it's a little technical in here, but if you're going to try to deny that you knew, that you didn't know fentanyl was involved in what you sold, kind of hard in today's age. We're no longer in the Miami Vice stage, and that dates me. And all of you who remember Miami Vice, where it was always pure heroin, pure cocaine. Mr. President, that's regarding the fentanyl. And the knowingness standard. The next section, Mr. President, deals with xylazine. And It's a compound that most of us had never heard of prior to a few years ago. It's a horse tranquilizer or a large animal tranquilizer used by veterinarians. It's now become a fairly common compound added to illicit street drugs. And I believe that the lab testimony was around 50% of the cocaine and other drugs that they test have some xylazine in them, which is pretty scary. The xylazine, unlike fentanyl, is not responsive to naloxone. So somebody who's been given xylazine is not able to be revived by naloxone, which is tried and tried. And oftentimes, the only way to revive them, if they can at all, is through CPR. If the person survives, the impact on the body of xylazine on a human body is oftentimes sores, loss of limbs, and other disastrous impacts. So what this bill does is make dispensing or sale of xylazine illegal, with the same penalties as we have for fentanyl. And the reason, the language also, was vetted with the Vermont Veterinary Association and others to make sure that it's still able to be used by our vets when it's appropriate. And it's not necessarily against the law to possess it. Obviously, veterinarians still can use it, but it's not approved for human use. One of the other more controversial sections of the bill has to do with dispensing or sale with death resulting. This provision establishes a permissive inference that the use of the substance was the proximate cause of the death if the substance contained fentanyl. A permissive inference suggests to a jury a possible conclusion to be drawn if the state proves certain facts, but does not require the jury to make that conclusion. Thus, a jury may conclude that if the substance contained fentanyl, it was the proximate cause of the person's death. Section 2 requires a default that the mandatory 2-year sentence, which is current law, for death resulting from an overdose, not be suspended, deferred, or served in the community. However, a court may deviate from that requirement if the court makes written findings on the record that the sentence will serve the interests of justice. I want to give you a couple of examples of overdoses, people that I actually know. One was a young man who used cocaine and xylazine. Didn't know he was using xylazine, by the way. Had a reaction to it, was in a motel room. The people threw him out of the motel room, threw him into the street, into the parking lot. Luckily, there was somebody there who had driven him, and that person was asked to drive him around the block to make sure he didn't die in the parking lot. Luckily, that person called the EMTs, and the person lived. I don't have a problem with a maximum sentence for somebody who does that, who sold the drug, throws somebody out into the parking lot and wants them to die somewhere else. Doesn't care. So it was brought to us, what about if it's two brothers? One brother gives the other brother. That's what this does. It allows the court some flexibility, but puts its reasons on the writing for its reasons on the record. The third example is about 20 years ago. It was St. Patrick's Day. and a young man that I'd had in my program. And I tried not to get close to too many of them, but it's not his real name, but we all called him Vern. And Vern had a tragic accident on an ATV and had serious back injuries and was prescribed at the time Oxycontin and other drugs. Got a habit, ended up leaving Bennington, went back to Rutland, started using heroin, and died of an overdose. And the people that were with him left him to die in that apartment. And because they didn't want to get prosecuted. So the state passed a law regarding immunity from liability called the Good Samaritan Law. That was in 2013. Many of you may remember working on that bill. And it provides immunity if you seek help. So the person who calls the police, stays with the person who's overdosing and seeks help, not going to be prosecuted. That's immunity. It also may answer one question for you, and I keep reading this. Senator Campion follows the Bennington scanner frequently. And there'll be a comment, well, somebody overdosed, why aren't they charging? Well, because if you overdose, this law provides immunity if you seek help to recover from the overdose. So you don't get charged. And it's 18 VSA 4254, immunity from liability. And in this bill, there's a section 17 on the Good Samaritan Law that provides for the Department of Health to engage in a public awareness campaign about the existence of this law in hopes of encouraging people to assist someone experiencing an overdose. That's kind of funny. We've had all of those things online, you've seen on TV. You know, you can get a strip to test your drug and blah, blah, blah. I haven't seen anything about the immunity that's available to you under Vermont law if you assist somebody in recovering from an overdose. Call the police, do whatever you need to do. So I'm hopeful that we will do that. And since we already know that 100% of the glassine bags that are tested contain fentanyl, I'm not sure what you need to test it for. Maybe that is some process. Finally, Mr. President, in the bill is section 16, which deals with flash citation for unlawful drug activity in a dwelling. If I might, Mr. President, if I could read from an article in the Bennington Banner.
Without objection, you may.
This was dated about gangs in Bennington. According to court documents and public sources, these hybrid gangs find convenient residents in and around the area through drug transactions with addicts here in Vermont. The person with an addiction is commonly offered drugs in exchange for an individual or several individuals to establish a trap, a slang term for the use of another person's residence as a location to distribute drugs. Often these addicts become indebted to the gang dealers inside their residence and are forced to sell on the gang's behalf, becoming in essence drug slaves on behalf of the gang. Many are threatened with violence or worse if they say anything or don't go along. Several locations in the Isaiah Rodriguez story served as those distribution locations, including many in Bennington. Isaiah Rodriguez is the individual who was shot, a teenager shot and killed and left in Danby, Vermont in the wintertime last year on the side of, in a snowbank. Including many in Bennington, Manchester, Pownell, Londonderry, Shaftesbury, Danby, and beyond. There are at least 8 known locations mentioned in court documents. And I'm not going to give the exact location of these trap houses, but they're in the Banner article. So we know they exist. We know what's happening. So the Committee on Judiciary added a section, was looked at by the Economic Development, General Affairs, and Economic Development, Housing and General Affairs Committee. That section requires the person cited or arrested for dispensing or selling a regulated drug to be arraigned on the next business day after the citation or arrest. And if the alleged illegal activity occurred at a dwelling where the person is not a legal tenant, unless the person is held without bail for another offense, the state's attorney is to request conditions of release for that person, which may include that the person is prohibited from coming within a fixed distance of the dwelling. The section is modeled after provision in current law that requires such a procedure for a person cited or arrested for domestic assault. Now I want to go back to the effective dates. Talk a little bit about the raise the age. There was a lot of debate in committee about what to do about it, particularly following the Columbia University study. And we struck what I would say is compromise on an April 1st, 2025 date to implement raise the age to age 19. And there will be reports required throughout that period. And to the Joint Justice Oversight Committee, the Committees on Judiciary, Appropriations, and others. And, you know, some of the compelling testimony, Mr. President, actually came from state employees from DCF who are overwhelmed right now with the acuity of cases that they're dealing with. And so we set up several benchmarks. But I want to make clear that those benchmarks not being met by the administration is not to be used as a reason to not implement on April 1st. It would take an act of the legislature to not implement that raise the age on the 1st of April, 2025. Your Committee on Judiciary probably heard from 40 to 50 people on this bill. And much of the testimony was difficult and heartbreaking, quite frankly. Mr. President, again, the vote was 4-1. I want to thank 3 members of Legislative Council who actually worked on this bill. Michelle Childs, who was the main draft person, but Eric Fitzpatrick and John Gray all contributed to different sections of the bill. Well, I hope that the Senate will approve this bill. And thank you, Mr. President.
Question is, shall the Senate adopt the report of the Committee on Judiciary? Senator from Madison.
Thank you. May I inquire of the presenter of the bill?
Senator from Bennington is in turn.
Thank you.
Thank you, Mr. President. I just have a couple questions of clarification to make sure I'm understanding the changes. In section 1 on the Big 12 juvenile offenses, there's a section that's a current law that's about offenses that would be charged in adult, a criminal division of the Superior Court.
Yes.
And those are for kids 14 and over. Those are the Big 12, right? And then the section 3, the new language is adding 3 that would just be for 16 and over. Is that correct?
Yeah, I believe that's section 2, but
okay, but that is essentially what's
that's
happening.
essentially the 3 new crimes are just for 16 and 17, 18 and 19, and when we get to 25.
Okay, that's okay. And then in both of those paragraphs, the current law C1 and then the new paragraph 3 on 1180 B3, I think it is on page 1187. It includes the language, unless the state's attorney files the charge directly as a youthful offender petition in the family court.
Correct.
And I ask about this because there was a case in my district that was fairly controversial involving a 14-year-old. And it was filed in the criminal division of the Superior Court. But the state's attorney could have chosen to file it under a youthful offender petition in the family division.
Yes, and it would have gone to the family division. It would have been a decision whether or not to treat it as a youthful offender. And then if it was treated as a youthful offender, it would go under the youthful offender law.
Okay.
But it would be, it's not a public process. It's a private, it's a.
Right. When it's under family, in the family
If it's in
division,
the
it's
family
private.
division, it's a private.
Okay, correct. That's what my understanding as well. Thank you. But are there standards or criteria that state's attorneys have to use to determine whether they're going to file something under the youthful offender petition, or is it simply just up to state's attorneys and their own individual
Up to the
judgment?
state's attorney in the initial filing, as I understand it. But the court or the defense can ask for it, but that would be part of the criminal case. So in other words, when the arraignment occurs, then the court or the defense attorney can ask for treatment as a youthful offender, but you've already gone through the publicity.
Right, exactly. And that's exactly what happened in Addison County. And so under current law and then under the bill as well, but it's not, the bill is not changing it, but under current law, it's really the state's attorney's individual preferences, and some may err on one side and some may err on the other side. Is that your impression? Okay. Okay. My second question is also sort of a clarifying question about it's under this section on xylazine.
Yes.
And then selling or dispensing a regulated drug, so that the sections, I believe, 14 and
Xylazine,
15 of the
section
bill.
14 is xylazine on 1192.
Yeah, so my question is the definition essentially of dispensing, because there's sometimes it says dispensing or prescribing, sometimes it just says dispensing, and sometimes it says dispensing or selling. And I'm wondering what is the difference between, I understand what prescribing is, but is dispensing just giving somebody
No,
something?
dispensing and prescribing, this is what the exceptions are. So no person shall dispense or sell xylazine except provided in subsection B. And then B, the following are permitted activities related to xylazine. And unfortunately, I have to go to the next page to dispensing or prescribing for the administration to a non-human species.
Right. No, I understand that. But then you go down to paragraph C on that same
Okay.
page, and it says a person
unlawfully-
knowingly and unlawfully dispensing xylazine. Is
Well-
dispensing, is that selling, or is there a difference between selling and dispensing?
Dispensing doesn't necessarily have to be sale.
Could be just giving somebody without
giving
exchange
somebody-
for money?
Without for money or.
Okay, but there's not a
Well,
legal
selling-
difference, the sort of impact is the same.
Yeah.
Okay,
Well, no, it's actually, if you dispense it, it's a 3-year felony. If you sell it, it's a 5-year felony.
oh, okay, there is a difference. Okay. Okay. This might be something that I need to talk to legislative council to understand a little bit better, but I think that helps me.
It's the same as the fentanyl statute.
Oh, I
Fentanyl
see,
law.
there's now, okay, no, I see it now under paragraph C. There's a selling and dispensing difference. Okay, all right, thank you. I thank the presenter. Thank you, Mr. President.
Senator from Caledonia.
Thank you, Mr. President. I would like to thank the committee. Section 16 reflects really unfortunate circumstances that many of our tenants and property owners have found themselves in. I thought at first it might be a regional issue, but I've talked with people that are involved in housing around the state, and that has to do when the drug dealer takes over an apartment and all the other tenants really feel terrorized for their own safety. And there's very little that can be done right now in a swift way. And this was a matter that I discussed with the chair early in the session. I discovered in talking with housing people around the state that in fact, it was a very common practice with the shortage of housing and with the concern that people have around their own safety, and with many of the individuals involved in drug trafficking. People are cautioned, don't attempt to intervene, be careful, but what can be done in a more expedited way. It's always been a problem. So I'm hoping that by having that flash citation, at least gives some ability to respond in a much more prompt way to situations where some of these, they're heart-wrenching, where people are in their 70s and 80s or might have young children and they're in, there's no place to move and they are just living in terror. So I wanted to thank the committee for taking up this issue because I do think it ties very much with housing availability and safe housing. So thank you.
Senator from Essex.
Thank you, Mr. President. Just before town meeting day, I had a forum in my community in Orleans County. We had it in Newport. And it was attended by the state police, the sheriff's department in Newport City, and our state's attorney. And it was a very great forum. We heard a lot of disturbing facts in that. One of the facts that we've heard is that these drug people are actually bringing in their own salespeople, younger salespeople, because of the laws that we have in Vermont as far as raise the age. And once we got into that, I think that was when all the horrors that we heard that were going on, the crowd could not believe that the state of Vermont was doing what we were doing with that, and that we had to go back and visit that a couple different times because they just couldn't believe, they hadn't heard that that's what the state of Vermont was doing. So I'm going to stand with the governor as far as on that maybe, as he said, that some of the laws that he signed about raising the age, probably he would go back and revisit that. I wish that wasn't in this bill. My state's attorney called me the other day. We've had 10 murders in Orleans County, 10 murders that are under investigation. Whether some haven't been solved or some have known, or you're never guilty until you're proven guilty. So we had 10 murders, and also in the state of Vermont right now, we're #1 in the nation as far as breaking and enterings, as far as people stealing firearms and selling them across the nation. They just had some, I think, were found in Alabama that were stolen out of the town of Irisburg, one of Senator Starr's and my communities. My hometown and Senator Starr's district. So I just, there was so much in this bill that I'd really like to support, but this raise the age is just a non-starter for me. It's a non-starter for my community. I do believe that we've got to get tougher on a lot of these penalties. Still, I do appreciate the Judiciary Committee taking this on, and just wish that we could have separated really what I would say real attempts at reforming and making penalties tougher, especially on drug use and what it does to our communities and the crimes that are committed. But I can't support this bill when we're raising the age, when the law enforcement communities are telling us that the drug people are bringing in their own salespeople of younger age because they know that they won't be charged as adults, but charged as juveniles. Thank you, Mr. President.
Senator from Bennington.
Mr. President, I may not have been clear. Raise the age, in my opinion, is not the problem. Raise the age is actually a positive. Somebody at Justice Lab found that. Number two, the Department of Children and Families testified in judiciary that the administration is supportive of raise the age, just not now for the age 19. That they wanted a delay. We accommodated them, and I worked with them and the committee to reach compromise on when that delay would take effect, and that was chosen as April 1st. There are a number of benchmarks that must be met, but the problem is not raise the age, in my opinion. Actually, raise the age has been successful with the 18-year-olds. The addition to the Big 12 goes along with raise the age, Mr. President. If you add to arson causing death as defined in 13 VSA 501, assault and robbery with a dangerous weapon is defined in 13 VSA 608, assault and robbery causing bodily injury is defined in 13 VSA 608C. Aggravated assault is defined in 13 VSA 1024. Murder is defined in 13 VSA 2301. Manslaughter is defined in 13 VSA 2304. Kidnapping is defined in 13 VSA 2405. Unlawful restraint is defined in 13 VSA 2406. Maiming as defined in 13 VSA 2701. Sexual assault is defined in 13 VSA 3252, and aggravated sexual assault is defined in 13 VSA 3253. And you add drug trafficking, and you add carrying a firearm while committing a felony, and you add aggravated stalking, you have 14 crimes that can either be charged as for a person as young as 14, depending upon the state's attorney's choice, or 16 in the last three that I mentioned. Mr. President, any of those crimes can, the 11 that I just mentioned, plus breaking and entering into an occupied dwelling currently, can be charged of a 14-year-old currently. So if you raise the age to 19, you can still charge that person if they commit any of those 14 crimes that I just mentioned under raise the age. Additionally, Mr. President, the court already has a process where if you commit a felony, if the state's attorney wants to go through it, and I admit it's not an easy process, but you can have the case rise up to the Superior Division or the Adult Division of the Superior Court. So for people to blame raise the age, I understand, it looks like weak, but darn it, it's proven. It's successful, it's working. It's lowering the crime rate, not increasing it. Kids are having better outcomes. I think personally that it's been successful. And my understanding of the administration's position is that they do support the April 1st date. Now, I don't know what they'll do in 26. I may not be here. But if they come back and ask for an extension, the legislature would have to give it to them. Can't be done without legislative action. But I'm sorry that I wasn't in Newport to defend raise the age, because I would have. Sometimes we like to blame something for a problem. In my opinion, raise the age is not the one to be blaming. We have fewer cops on the street. One reason we don't solve crimes. We have a huge vacancy rate in our state police. We already know that not solving crimes is the worst thing you can do, because people aren't deterred from crime. They're deterred because they're going to get caught. If you don't think you're going to get caught, probably why everybody was passing me at 80 miles an hour the other day when I was driving 75. Oh, excuse me, I just admitted to driving fast. But most people were passing me. So maybe it's because they didn't think they'd get caught. Thank you, Mr. President.
Senator from Chittenden Central.
Thank you, Mr. President. I'd like to offer some good news to my colleague from Essex. And that is, if you support the bill, other than the raise the age provision because you don't like raise the age, this is the bill for you. Because what this does is, for a third time, delays the onset of raise the age. So if this bill were to die from enough people voting no, raise the age would go into effect much sooner. So anybody who doesn't like raise the age, that should be an additional attraction to you about this bill, not a reason to vote against it. So if you like the other provisions and raise the age is your thing, then I would just urge my colleagues to rethink that piece. I want to say that this was a tough bill for me. It contains some things that I had to swallow hard on, one of them being the third delay of raise the age. But there were also provisions that I think will produce more incarceration going forward. And the administration from the beginning made it clear that they were not going to come across with greater resources. And so the Senate and the House, the other body, we will do what we have often done, which is to fill those gaps to make sure that if we're doing something for, in the name of public safety, we have the resources to make it a successful policy. But I want to say that overall, this addresses persistent and vocal needs that we've all heard from in our communities. Decker Towers in Burlington has had issues with people terrorizing the occupants, no tools for law enforcement to get those individuals who are selling drugs, using apartments that they've in effect taken over. No way to deal with that. The flash sighting here will help with that. So among other things, situations in my community, I hope will be positively impacted. I want to close by saying that the Judiciary Committee, as currently constituted, is a very effective group, all five of us. We have differing opinions on matters of public safety, especially around addiction, how we'll deal with crime related to addiction. But I have been heartened by the way the five of us work together. And what we have come out with, S4 last year and this bill this year, continue the Judiciary Committee's path on reform, but at the same time, they recognize that there are very, very troublesome crime patterns that we need to be responding to as well. So I think we have, on this issue, found a way forward, as we've done on many others this session. It won't be the last that you'll see from the Judiciary Committee. We've been doing a lot of good work, but again, my thanks to the chair for his leadership on that.
Question is, shall the Senate adopt the report of the Committee on Judiciary? Are you ready for the question? If so, all those in favor, please indicate by saying aye.
Aye.
Those opposed indicate by saying nay.
No.
The ayes appear to have it. The ayes do have it, and you have adopted the report of the Committee on Judiciary. The question now is, shall the bill be read a third time? Roll call has been requested by the Senator from Bennington. The question is, shall the bill be read a third time? Are you ready for that question? Senator from Chittenden Southeast.
Thank you, Mr. President. Since a roll call was requested and my vote will be on record, I, with deep respect, would like to interrogate the presenter of the bill so I can fully understand our vote.
The Senator from Bennington is interrogated as a reporter of the bill.
Bear with me, Mr. President, because I am using today's calendar to reference various sections, but I'd like to start by understanding existing law in section 13 on drug crimes. And Mr. President, the question is, if this is the reference section in the new language under section 1 that further criminalizes for youth trafficking a regulated drug. If this now means that a 16-year-old can be charged as an adult for trafficking a depressant or a stimulant or cannabis.
Yeah. Anyway. Drug trafficking.
Okay, so
You're looking at, actually, you're looking at the additions to transfer from family division to Superior Court. You're on page 1187.
on page 1187, sub-Roman numeral 2
Yeah,
is,
trafficking a regulated drug in violation of 18 VSA chapter 84.
and the definition of regulated drug then exists on page 1192, section 13, and includes cannabis.
Yeah, but it's like 50 pounds or something. Let me find the drug trafficking statute. It's not 2 ounces. I gotta find my glasses.
Okay.
I can, the amount of cocaine trafficking was 150 grams.
Okay.
The amount of fentanyl is 70 milligrams. I don't have, the methamphetamine is 300 grams. I think the marijuana is 50 pounds, but I could be corrected.
And
You asked about cannabis.
I asked, Mr. President, I asked about cannabis and a depressant or stimulant drug.
Well, stimulant, I guess, would be methamphetamine.
If that excludes methamphetamine in subsection B,
Pardon
Mr.
me?
President.
You have a brief recess to check on.
We'll take a brief recess till the fall of the gavel. Senator, please come to order. Senator from Chittenden Southeast has the floor and was interrogating the senator from Bennington County.
Thank you, Mr. President. I believe council has given us a helpful clarification that the reference to regulated drugs in Roman numeral 2 on page 1187 only refers to 4 regulated drugs. I may not remember them, but something like fentanyl, cocaine, 50,000 pounds of cannabis, 50 pounds. Anyhow, it does not include the full list of regulated drugs in section 13. So moving on to my just final couple of questions, Mr. President. In the same section 13 where knowingly is now redefined, Mr. President, if any of these regulated drugs listed above is potentially cut with xylazine or another drug that has additional offenses like fentanyl, and the person who provided or dispensed or sold that substance to someone else should have been consciously aware of a substantial risk, can that be used against a minor as well?
Only if they were trafficking those 4 drugs.
Okay.
In my those 4 drugs.
Okay.
But just so that everybody's clear, it's cocaine, fentanyl, marijuana, heroin. Are the 4 drugs that can be trafficked. And the marijuana is 50 pounds.
Mr. President, I will seek more clarification before third reading so that we could move on. My final question is in reference to section 12. And I'll preface this by saying that my concern is often that when we both look sympathetically at some youth and some offenses and further criminalize others, we open a door pretty wide for racial and ethnic discrimination in our state. And as a member of the Joint Legislative Justice Oversight Committee, I have great interest in following these changes as they relate to racial disparities in our criminal justice system. And I wonder if the committee took testimony on that issue, or if any of the items represented in further study for section 12 help us understand continued or new racial disparities that may emerge around different treatment for different youth.
The testimony I remember is from the Office of Racial Equity. There may have been other testimony.
Mr. President, and did that testimony impact any changes in the bill?
But yes, I think adding the standing capacity, balance, and restorative justice came from one senator, and I may have been influenced by that. I don't know. You'd have to ask, or they could volunteer that information.
Mr. President, the Office of Racial Equity give a positive or neutral endorsement of this bill?
No, they were more concerned about the knowingly standard and the death result.
Thank you, Mr.
Not
President.
on- They didn't express concerns about 12, section 12.
Thank you, Mr. President. I thank the member, and putting all of these pieces together, while on the one hand, we are trying to acknowledge that there's a transition from youthfulness to adulthood and recognize that we have developing brains at a young age, while also criminalizing in new ways and ways that I think might have unintended consequences, our young people from the ages of 16 to 22 is unfortunately not something I can support, and I will be voting no.
The question is, let me just pause for a second. Question is, shall the bill be read a third time? Are you ready for the question? If so, the secretary shall commence to call the roll.
Senator Baruch.
Yes.
Senator Bray.
Yes.
Senator Brock.
Yes.
Senator Campion.
Yes.
Senator Chittenden.
Yes.
Senator Clarkson.
Yes.
Senator Caldwell.
Yes.
Senator Cummings.
Yes.
Senator Gulick.
No.
Senator Hardy.
Yes.
Senator Harrison.
Yes.
Senator Hashim.
Yes.
Senator Ingle.
No.
Senator Kitchell.
Yes.
Senator Lyon.
Yes.
Senator McDonald.
Yes.
Senator Mazza. Senator McCormick.
Yes.
Senator Norris.
Yes.
Senator Pershwit.
Yes.
Senator Ron Hinsdale.
No.
Senator Sears.
Yes.
Senator Starr.
Yes.
Senator Buhofsky.
No.
Senator Watson.
Yes.
Senator Week.
Yes.
Senator Westman.
Yes.
Senator White. Senator Williams.
Yes.
Senator Renner.
Yes.
Senator Mazza. Senator White,
Please listen to the results of your vote. Those voting yea, 24, those voting nay, 4, and you have ordered third reading of S 58. Senator from Chittenden Central.
Thank you, Mr. President. That was an almost exact hard stop at 3. Thanks to all involved. With that, I would move that the Senate stand in adjournment pending announcements until Friday, March 22nd at 11:30 a.m.
Are there any announcements? Senator from Caledonia.
May I inquire of the contemporaries?
The senator from Chittenden Central is interrogated as the proposer.
I'm just looking at the calendar and I'm looking at the workload that your 2 money committees have. And I'm just wondering if we perhaps should start a bit earlier tomorrow morning than 11:30, considering I'm not getting bills out of finance until tomorrow, and I'm just really concerned about the time.
Mr. President, the chair read my mind. We had been going to inform folks of a 10:30 start date tomorrow, assuming that we were successful in getting buy-in from morning committee chairs. But with that, if I might amend my motion, Mr. President.
You certainly can withdraw your prior motion and make
I
any
will
motion you'd
withdraw
like.
it and make a new motion. Pending announcements, I would move that the Senate stand in adjournment until 10:30 a.m. tomorrow, Friday, March 22nd.
Are there any announcements? Senator from Washington.
thank you, Mr. President. Senate Finance will meet 10 minutes after the fall of the gavel.
Senator from Bennington.
Thank you, Mr. President. Senate Education will meet 10 minutes after the fall.
Are there any? Senator from Essex.
Thank you, Mr. President. Senate institutions will meet 10 minutes after fall of gavel.
Senator from Madison.
Thank you, Mr. President. GovOps will meet at 3:15.
Senator from Chittenden Central.
Just a note, Mr. President, on what we did and did not do today. We had hoped to do S-258 today. I know there are some folks who attended with that expectation. My apologies. Our debates on S-18 and S-58 ran longer than I had expected. But we will look to take up S-258 tomorrow. And so if there are questions along those lines, direct them to my office. And again, apologies for that change.
Are there any further announcements? Seeing none, the senator from Chittenden Central has moved that the Senate stand in adjournment until 10:30 on Friday, March 22nd. Are you ready for the question? If so, all those in favor, please indicate by saying aye.
Aye.
Those opposed indicate by saying nay. The ayes have it, and the Senate will stand adjournment until 10:30 a.m. Friday, March 22nd.